Notaries play a fundamental role in both national and EU company law. Just to mention the 5 most populous member states of the European Union where notaries have competences in company law and M&A, it should be highlighted that in Germany, Italy, Spain, the Netherlands and Belgium, on a daily basis, notaries assist companies in carrying out their activities. In this perspective, as they do in other fields of private law, also in company law, notaries provide preventive justice, and their involvement reduces the cost deriving from litigation. In a word, by controlling the legality of transactions, notaries provide support to businesses and entrepreneurs while advancing the public benefit. It is not surprising that even the very first instrument of European company law, Directive 68/151, the so-called First Company Law Directive, made 3 distinct references to notarial instruments, highlighting, in particular, the importance of the involvement of notaries to ensure that preventive controls are carried out while incorporating companies and when the bylaws or statutes of companies are modified. These references still survive today in Directive 2017/1132, the so-called Codified Company Law Directive, which consolidated in a single piece of legislation the different company law directives enacted by the European Union over a period of almost 50 years. In fact, after the first Company Law Directive, also other harmonization directives acknowledged the importance of notaries in company law, recognizing the relevance of their role, for example, in national mergers, national divisions, and in cross-border mergers. Moreover, even outside the scope of the Codified Company Law Directive, notaries have been granted other competences by Council Regulation 2157 of 2001 on the statute for a European company, and by Council Regulation 1435 of 2003 on the statute for a European cooperative society. Namely, these competences concern the cross-border mergers that result in the creation of one of these European entities and the cross-border transfers of registered office of these same entities. More recently, Directive 2019/1151 on the use of digital tools and processes in company law and Directive 2019/2121 on cross-border conversions, mergers and divisions, which both amended the Codified Company Law Directive, made even more references to the role of notaries in the online incorporation of limited liability companies and in other cross-border mobility transactions like cross-border conversions and cross-border divisions. In light of the importance the European Union and Member States give to the preventive controls carried out by notaries in company law, it is clear that these professionals act as gatekeepers in the interest of the different parties involved in the transaction in which they take part. Being independent and impartial public office holders who have received a delegation of authority by the government, notaries also promote legal certainty in the interest of the society as a whole.